All right, good afternoon, everyone. I'm Lisa Foster. I am the co-director of the Fines and Fees Justice Center. Welcome to what I hope will be a webinar that sparks a firestorm of litigation around the country. People have been talking about debtors' prisons for court debt for a while now. In 2010, the ACLU and the Brennan Center both issued reports decrying the practice. In 2014, Joseph Shapiro at NPR, Sarah Stillman at The New Yorker both wrote articles about debtors' prisons. And then in 2015, Michael Brown was shot in Ferguson, Missouri. The community erupted and the Justice Department issued its eye-opening report. Many of you have challenged debtors' prisons in cases around the country, and many of you have secured important settlements and victories in those cases. But many courts continue to lock people up using arrest warrants issued when a person does not pay or misses a payment under a payment plan. One of the courts that routinely relied on warrants to collect court debt was the Elmore County Magistrate Court in Idaho. And one of the people subjected to a warrant of attachment by the Elmore County Court was Roxanna Beck. Ms. Beck had pled guilty to a minor misdemeanor, frequenting a place where controlled substances were used, sold, or manufactured. She was convicted, and despite her attorney's request that fines and fees would be waived, Ms. Beck was ordered to pay $638.50. Parenthetically, $150 of that was the fine, and the rest were fees and costs. She signed a payment plan agreement that required her to pay $25 a month. That agreement also contained a clause that said if she missed a payment, the full amount would be due and a warrant for her arrest might be issued. 3 months after the first payment was due, a deputy clerk of the court filed a motion and affidavit in support of contempt proceedings. That same day, based on that affidavit, an Elmore County judge issued a warrant of attachment for contempt against Ms. Beck. The warrant gave her 3 choices. She could pay the full amount and expunge the contempt. She could pay bail in the amount of $6,400 and appear in court at a later date, or she could go to jail and appear in court on the next judicial day. Ms. Beck was arrested several months later in another county, and she spent 7 days in jail before she was transferred to Elmore County and arraigned on the new charge of contempt. At arraignment, she entered an Alford plea to the contempt charge and was sentenced to 5 days in jail, the maximum allowed under the statute, given credit for time served, credited $70, a mere $35 a day against her court debt for the extra time she spent in jail, and she signed a new payment plan agreement, $25 a month, with the same clause warning her of the consequences of missing a payment. Less than a month later, she and her attorney filed a petition for writ of prohibition with the Idaho Supreme Court, seeking an order prohibiting the court or any of its judges from issuing future warrants of attachment against her or other similarly situated people. The Idaho Supreme Court issued a temporary writ and ultimately a permanent writ, preventing the Elmore County Magistrate Court from issuing warrants of attachment for unpaid fines and fees without first issuing an order to show cause for contempt, providing notice and an opportunity to be heard on the question of whether the person had the ability to pay the amount owed. And the court had to make a finding on the record that the person before them had the ability to make that payment. In a remarkable opinion, the Idaho court ruled on state statutory and constitutional grounds and under the 4th and 14th Amendments to the US Constitution. The reason we have such a comprehensive and rich opinion, or any opinion at all, is because the defender who represented Ms. Beck at her arraignment in Elmore County realized that there was something fundamentally wrong with what had happened to his client and raised a multitude of claims challenging what had occurred. With us today to talk about the case is Pete Wood, the attorney who represented Ms. Beck, filed the writ of prohibition and argued the case for Ms. Beck in the Idaho Supreme Court. Pete was a public defender in Montana and Idaho for 3 years, and he is now in private practice, although the majority of his work still consists of contract public defense work. Joining Pete is Orion Danjuma, who was until earlier this month with the ACLU Racial Justice Program, one of 9 amici in the case, including Fines and Fees Justice Center, who filed a brief in the Idaho Supreme Court supporting Ms. Beck. Orion is currently counsel at Protect Democracy, working on elections and voting rights. For the 6 years prior, while with the ACLU's Racial Justice Program, he focused on the impact of fines and fees on vulnerable communities, as well as issues at the intersection of voting rights and racial justice. Before joining the ACLU, Orion clerked for the U.S. Court of Appeals for the 7th Circuit and the U.S. District Court for the Middle District of Alabama. I'm also going to exercise my moderator's prerogative and introduce Tim Curry, who joined Fines and Fees Justice Center this past summer as our research director and amicus counsel. Tim organized today's webinar, and he's going to help us field questions from all of you. We want to make this webinar interactive among the 3 of us and with those of you participating today. I'm going to pose some questions to Pete and Orion. The first 2 will be broad and they'll have a chance to answer for 10 or so minutes. And then I'll pose more targeted questions. We are going to leave about 20 minutes for direct questions and answers for all of you at the end. However, if you have questions at any point, please put them in the Q&A box, which you will see at the bottom of your screen. Tim will pose relevant questions to us as we go along and during the Q&A period. We are recording today's session, so if you have colleagues who were not able to attend or know someone who you think might be interested, a recording will be available of the webinar on Fines and Fees Justice Center's website. So we're going to start with Pete. Pete, tell us, what's a writ of prohibition? What issues did you raise in your writ? And how did the Supreme Court respond?
Yeah, so I guess I'll turn to my PowerPoint now to answer that. It'd probably be easier than anything else. Can you all see that okay? All right. So that's my wonderful art there. I won't bother you with that. A writ of prohibition is simply a command, but the key, it's a command to ask a higher court to tell a lower court to stop acting in an unlawful way. Doesn't have to be a court, but for our purposes, that's what we'll use. The key to understanding writs of prohibition are that it's about preventing future harm. It is not about a remedy for what's happened in the past. And I cannot emphasize that enough. And you'll see that I keep underlining in the future, because that's what this is about. It's particularly useful for issues that easily avoid appellate review, like this one. And a more cynical view is that it's sort of a way of tattletaling on the lower courts when they're doing something wrong. It's a way to get the issue up in front of in this case, the Idaho Supreme Court, or typically the higher court. It could be a district court. A petitioner seeking a writ has the burden to show that the lower court is acting without jurisdiction. Now, as one caveat, you'll see there's a lot of writing in here, but it's my understanding that this PowerPoint will be available later, so I'm going to go quite fast through it, but you'll be able to come back to it later. The key is that the term jurisdiction does not mean subject matter jurisdiction. The term jurisdiction in a writ simply means that they're violating the law or violating the Constitution. So when you say that the lower court is acting outside the jurisdiction, you're saying they're violating the law. And then second is that there's not an adequate remedy. There's no other, typically appellate remedy, if you will. Lisa already went through the facts in the case, so I'll skip through that. One of the things to know about writs too is that they're incredibly fast, or they can be, which is kind of nice. So in this case, the writ was filed for Ms. Beck on December the 4th. On December the 11th, a week later, the judges, the writ was filed a motion to dismiss, arguing and filing a document saying that they'd changed their policies and they wouldn't do it anymore. 19 days later, the Supreme Court issued a temporary writ, and approximately 200 days later, they issued this formal opinion. So things happen fast with writs, which is kind of nice. Exceeding the jurisdiction. So, another way to say that again is that how are they breaking the law? We argued that they were breaking the law in 5 ways, but the big two for you all to keep in mind is going to be that the failure to pay has to be willful, at least in Idaho for contempt. I presumably other places as well. For criminal contempt, it's got to be willful. And so, if you don't have evidence of willfulness, you don't have evidence of you don't have probable cause for a warrant. So the warrant will issue that will violate the Fourth Amendment unless they've got some information that the individual has the money to pay but didn't do it. And that's almost never going to be the case. The other one is that under the 14th Amendment, holdings in Bearden and a few others, it violates the Equal Protection and Due Process Clause to arrest people without first holding a hearing. And so if you can't incarcerate somebody without holding a hearing first, then by definition you can't issue an arrest warrant, which leads to incarceration prior to a hearing. The second prong, no adequate remedy. Again, you'll keep seeing I'm underlining future. That's what this is about. This is about saying that there's no future remedy, or there's no remedy for future harm. And this is not about the unlawful arrest that happened yesterday. This is about preventing the unlawful arrest tomorrow. And sadly, as I'm sure a lot of you deal with on a day-to-day basis, that debt never goes away. Our clients have no money, and the debt is always there. So if it's a practice to arrest people when they don't pay, then the writ of prohibition is particularly well suited to deal with that. What the decision means, at least in Idaho, obviously, because it was an Idaho Supreme Court decision, is that courts can't file contempt charges and automatically issue warrants. They now have to issue a summons and personally serve it and set an ability to pay hearing. Obviously, if the defendant doesn't appear after they've been personally served, then a warrant could be issued for failure to appear. But the fact that they have to be personally served is the big issue, because, again, sadly, as people in this line of work know, our clients move about every 3 days. And so the idea of needing to personally serve them for these hearings is incredibly difficult. And just putting it in the mail, if that were enough, you basically evade the whole issue. So the personal service thing is a big deal. Why is this such a good tool for this issue? It's such a good tool, this writ of prohibition, for solving this unlawful arrest problem, because a standard appeal is generally not possible. So if you're arrested and then you plead guilty, obviously, generally, you're not. The only thing you really have to appeal at that point would be the conviction, but the conviction for contempt is a separate issue than the unlawful arrest. And if you don't plead guilty and win a trial, then there's nothing to appeal there. Incidentally, you should win a trial on those back, because you can't prove the willfulness element. But again, it doesn't matter, because the standard appellate remedy would never be there, because the issue is not the conviction or not. The issue is the unlawful arrest. Second, of course, as noted before, the writs are about future harm. So you have this situation where you're saying, look, this happened in the past. I was unlawfully arrested, and then I still owe this debt. I still have the money, or I still owe the money. And so this could happen tomorrow. So I'm asking the court for this writ to issue an order saying, do not do this again in the future. And also, writs are fast, as sort of noted before, and they're an option that is available to public defenders. They don't take a lot of resources, obviously. They're not like filing civil litigation or all this kind of stuff. It's a quick remedy if it works, obviously. So Pete's final rant. It's very important in my view to have the right case. So if this is happening in your area, get together and talk to some of your colleagues or whatever and find the bad case. Find the case with egregious facts. In this case, this was during COVID, and Ms. Beck spent 7 days in jail, even though the most time that you could spend on a contempt is supposed to only be 5 days. Whatever the issues are, look for one that's got some egregious facts to bring it up. Second of all, I don't believe that this is a process is used. It's frequently, or I hear a lot that people, courts are doing this to quote generate revenue. I mean, if that's the case, in my experience, it's incredibly bad idea because it doesn't work. These people don't have any money. My personal view and experience is that they're doing it because it's easy, and the issuing arrest warrants automatically when people don't fail to pay, just generating them and out the door is easy. That's why it's being used, not because it's efficient. And so if you understand that, then you say, okay, well, how do we stop this problem? Well, you make it difficult, and you make it difficult by saying, this is unconstitutional and we're going to challenge this. And now we're going to have ability to pay hearings, and we're going to have to personally serve people summonses, and that it will stop because it's the difficulty of it, in my view, that's the key problem. So my second final rant, obviously the Beck decision does not address the bigger issue, which is, imposing the fines to begin with. This only deals with the arrest. Second of all, you've still got the issue of the courts employing terribly draconian things like putting people into collections, which just is, enormous interest rates and just crushing these people. And at least in Idaho, a lot of counties divert money. I think it's stealing, but out of people's taxes. So when people get their tax returns, it's automatically diverted to the court if they owe money. I'm absolutely convinced that this is illegal, but it would take civil litigation, which is my little hint to Orion here and you all, that unfortunately, something like the writ is good for arrest issue. I don't think it's so good for this issue, but this is another issue for a different day. But it doesn't, just to say, it doesn't solve all the problems. Included in this today is there'll be some templates, and I believe there's going to be a folder sent out tomorrow or something that has the documents that were filed, but there's also going to be, in particular, a couple of Word documents, one specific to the Writ of Prohibition. I've sort of pared it down. It's got obviously Idaho stuff in it, but it's also got federal stuff in it. My hope with you all is that I know you're incredibly busy. I get it. Put these in there as Word documents with the hope that you'll just copy and paste them and use them. I think of all the things about this, at least from my perspective that I'm providing today, I believe these templates will be by far the most beneficial. I can't speak for everybody, but in my experience, you go and you hear things and you're like, God, that's a great idea. I should try that. And then 5 minutes later, I can't remember it. I hope that this will prevent that. And then also, you have my explicit permission to copy and paste and file, change your facts and adhere to your state law, whatever it is. But most of these issues obviously are federal constitutional issues, so you shouldn't take too much messing around with. I'm happy to help in any way I can. This is an incredibly important issue, and something that I know that is just really, really taxing on not only our clients, but as public defenders, seeing it every day and seeing the pain it causes is just a bad deal. That's my email. Please email me if you have any questions. If you're going to file one and have some questions or want some help or whatever, I'm happy to help in any way I can. So thank you.
Thanks, Pete. So, all right, I'm going to turn to you now and ask you to give us, if you would, an overview of the kind of national landscape around fines and fees litigation and how you see this Beck opinion fitting in to the jurisprudence of fines and fees and how litigators might be able to use this opinion. And you're on mute.
I'm mute. I think I would have learned that by at this point in the pandemic, but apparently not. But good afternoon, everyone. It's a real pleasure to be here with you and to get to speak to you about really what I think is a very momentous decision and in the struggle against the criminalization of poverty that arises from fines and fees. And I really think this is an example of all of the sort of pieces of the system kind of merging together in a really sort of productive and useful way. We have Pete, who we're really very grateful, like is the origin of this case. The people on the front line who are the public defenders, a brilliant one who's a representative of the public defender community and knows all of the ins and outs of the way that the local system can work and is familiar with the types of abuses that are being seen in that local system, being connected to this national group of advocates who've been studying the burden of fines and fees on communities across the country. And then finally, a court system that is responsive, a court system in the state of Idaho that I don't know that I necessarily would have predicted, but was very much responsive to what it perceived as a systemic problem. And all three of those things, I think, united here to produce something that I really hope can be a roadmap for advocates at every level of that system to proceed in the future. And one thing I'll say just to start off is, Lisa was kind enough to invite me here, and I'm really glad to share my thoughts, but I'm just an envoy of the much broader community of folks who are involved. We were sort of brought in by folks from the Berkeley Policy Institute, our partners at the Institute for Justice and Cato Institute, who come from a very different ideological background from the ACLU. We all really united on that. So I'm here really mostly just as a spokesperson for those individuals. But the broader problem that this case raises and why it can be such a, I think, obviously precedent setting, but something that provides a roadmap for us to go for in the future is that the issue of warrants being used as a debt collection method by states is something that is happening across the country. And we've seen it in time and again in state after state. And it is a type of abuse that often happens in invisible places, in margins, where the people who are subjected to these types of injuries are often the most vulnerable, the least likely to know about their rights, and the least able to sort of assert them. And the impact on the communities affected by these policies is incredibly disastrous. One of many cases that the ACLU was involved in is one in South Carolina, Brown v. Lexington County, where not identical, but a very similar system of bench warrants being used as a method of debt collection resulted in thousands of people being jailed. And our 7 clients were jailed between 28 and 90 days. And in that period of detention, they lost their jobs. Some of them almost lost custody of their children. Some of them had major, major health complications. Even a much shorter stay than the one that we perceived in that case can have disastrous effects on people's lives. Pete already mentioned this, but he said understood, like, why are they doing this? Like, what's the purpose for it? And I think sometimes it is to just get the most money from the largest number of people possible, but it is catastrophic for the broader kind of public policy concerns, because someone who's jailed is just not going to be able to pay back their fines. They're much more likely to lose their job, to cause months and months, often years of disruption in their lives. That's what we saw here. So what is important about this decision is that I think that, well, there's a number of different ways that this decision is important, but one of the things that I think is particularly notable is that it's a decision that from the state court, from the Supreme Court of the state of Idaho. I will tell you that a lot of the advocates in the civil space, for many reasons that we can get into in further discussion, talk about this, try to enact broader policy change through the federal court system. And there's a logic to that. Federal courts can provide precedent throughout a region or indeed across the entire country. But here, and one of the reasons why it's been hard to go to state courts is that state courts are often not inclined to reform their own system. They're often comfortable with the way that things happen. And what I think is really extraordinary about this, and I want to talk about the first procedural parts of this case, is that, Pete files this extraordinary writ and gets us the equivalent of a preliminary injunction in the civil context, gets a sweeping ban in the entire county against this issue. And that, to me, that to all of the advocacy community was a real signal that the individuals on the Supreme Court of Idaho knew that this was a systemic problem. And they were interested not just in addressing it in this case, but providing guidance to all of the lower courts to ensure that it wouldn't happen in the future. That is really positive because state court systems are often really overloaded. They're really, really busy. But this is an example where a court essentially said, we need to provide some guidance so we know that the lower courts in the state are doing the right thing or trying to comply with the Constitution. And that is a really valuable technique, and that's a real win for this decision. The other reason why I think this decision is really important is that it understands the core of the Bearden doctrine. This is the Supreme Court's seminal case that barred held that it was unlawful to revoke probation for someone simply for failing to pay fines and fees assessed at sentencing. And there's a number of analysis in this decision that where the Supreme Court essentially, where the state essentially said, Bearden is a sort of limited, narrow decision. It only involves the circumstances of probation revocation. That's like where this decision applies. It doesn't apply in this different context that Pete was involved in with warrants. And the Idaho Supreme Court said, no, absolutely not. The underlying principle applies here in the identical way as it did in Bearden. And that is something that I will tell you, many federal courts, many other state courts haven't understood that core message, even though it's written right into the text of the Supreme Court's decisions. So this was a really great example of where basically, they looked past the invitation to interpret Supreme Court precedent really narrowly and got the underlying principle. It doesn't make sense, and it is unconstitutional to punish individuals if they're poor. And then finally, although this wasn't, discussed, I think, explicitly, I feel that this decision did implicitly recognize the public policy consequences to imprisoning people for non-payment if that non-payment is willful. And what I think that that advocates in the community can do now is to use this model to leverage it in state courts and potentially in federal courts in civil litigation, and by distributing it to public defenders to show that a state Supreme Court has understood how this works in its own system. And all of the states have very different systems. They have different systems with writs. They have different systems of warrants. Some are called capious warrants. But the fact that this understood the core of Bearden and understood that principle and translated it into its state law, that provides a roadmap for advocates to do the identical thing in other states where they're seeing these problems. The final thing I'll say is, we've expressed this many times, but we're like unbelievably grateful to Pete for flagging this and to the community, because again, that's how all of the pieces of the system kind of came together in this particular case. But one of the biggest concerns is abuse is happening to folks who don't have public defenders or who otherwise kind of evade the knowledge or understanding of the advocacy community that's focusing on these issues. So what I hope some of this webinar and what some of this opinion does, and some of Pete's PowerPoint does, is gets the word out. Because even if public defenders aren't representing a client, some clients have misdemeanor offenses, and we've seen them be jailed unconstitutionally on misdemeanor offenses where they never got a public defender. They often are some of the best witnesses for some of the worst abuses. And that's a way for us to know where the problems are most serious so that we can start leveraging and applying the best resources to solve them. So that's some of the way that I see this really amazing opinion being used in the future.
Thanks. And let me just underscore something that Orion just said, which is sort of, as you folks are out there, we know sometimes public defenders see things. In this case, it could even be after the fact, and think, I don't have the resources to take a case to my Supreme Court. If you see a case and you think that it's ripe for a writ or for civil litigation or presents facts like these, don't hesitate to call us at Fines and Fees Justice Center, me or Tim, or email. We'll find somebody who might be able to take the case if you don't think you've got the resources to do it. There are litigators who are interested in these cases, both public interest litigators around the country, as well as pro bono counsel. So that's just an open offer. Pete, the county, or the judges in the county, tried and almost succeeded in mooting this case. Can you explain what they did and why, in your view, it, even if the case was mooted, even if the Supreme Court, in its exercise of discretion, decided not to take this case, it's still important to bring writs like this?
Yeah, sure. So the writ was filed on Friday, December the 4th, 2020. And the following Friday, December 11th, 2020, and there'll be documents that'll be included in that you'll be able to see if you want. The judges filed, lower court judges filed a motion to dismiss the writ, and included with that was a written policy that they would no longer issue these unlawful arrest warrants. So even if it had ended there, I think it would have stopped. Frankly, I don't know if it would have gotten to the degree it did had it not been for the great amicus work and everything that came in that sort of pumped, I think, the issue up and made it look, made the Idaho Supreme Court realize, the enormity of it. But it is something that I think everybody knew it was wrong. It just needed to be put out there, how bad it was, and it was sort of just gotten used to it. When you file that writ to the Supreme Court in your state, the Supreme Court now knows what's going on. And frequently, I don't think people are aware what's going on. And immediately, it's just this sort of hair back moment. I think that even had it stopped there, it wouldn't obviously have gone statewide, which was better, because I know this was happening in other places in the state of Idaho. But I think it would have stopped in Elmore County. And that would have been a win. So I think that I would encourage all of you to file these things as public defenders. At least I feel so much of the time so incredibly powerless to do right by what's happening. And this is one instance where I think we've got a tool that is actually uniquely well suited for this problem.
Brian, can you talk for a minute about the amicus brief in this case? And whether you think it mattered, and what do you think makes for a good amicus brief in fines and fees litigation?
Yeah, so I mean, I guess I maybe don't know if I know sort of most broadly what makes the best amicus brief in this case. In all circumstances, in this case, I think we know it mattered to some extent because the court itself mentioned the brief and well, the way that this, I'll explain it sort of procedurally. One of the issues in the case was one of the issues that the state raised was the fact that Ms. Beck hadn't necessarily seen the procedural defect about the verification of the petition. And that is sort of a real technicality, right? And it's something very unique to Idaho state law. And in some other cases, we've seen circumstances where an important constitutional issue is at stake, and the Supreme Court of that state kind of ducks it. It doesn't want to really deal with it because and notes that there's some sort of procedural impropriety which sort of avoids the issue or allows it an escape hatch to not sort of deal with it. And I think in this case, one of the things the amicus brief did was highlight that this is a systemic problem and you shouldn't just look at it as one case. So whether or not an I was perfectly dotted here or not, this is an instance where the state Supreme Court needs to come in and provide some guidance to lower courts. So I think that's one of the key ways that it made a mistake or it made a difference is by really emphasizing that this isn't an isolated incident, that this is a broad systemic incident and it needs guidance from the state Supreme Court. What I think is particularly notable about the amicus space in the fines and fee world is that it is so cross-ideological. So that's the second main thing that I think is unique to this type of advocacy and that does not exist in other areas of civil rights and constitutional rights. We had a massively cross-ideological group of amici from the ACLU, the Racial Justice Center, the local ACLU affiliate, but also our partners at the Cato Institute and the Institute for Justice who've done sort of heroic work on fines and fee issues over the past several years. And that alliance, I think, really can help to show us, to show to a court that this isn't an issue of politics, at least in the traditional way. This is an issue that crosses ideological lines and is really about just the Constitution, what the precedent of the Supreme Court and the meaning of the core constitutional rights at issue. So that I think helps is to have a broad array of allies on this. And then finally, because Pete got this early preliminary injunction type remedy from the state Supreme Court, we knew, I think, that the state Supreme Court was interested in this issue and they were concerned. Like Pete raised such serious concerns in his initial petition. So the other part of the success is if a court is leaning towards going a certain way, we want to provide them with the ammo, with a national perspective to ensure that they know that they're not sort of an outlier, that in fact that they would be complying with the black letter law of Bearden, Tate, Williams, all of the core doctrine at issue, and a way to guide them through what I think the state used as wrong but maybe confusing arguments. It's a way to sort of anticipate and provide them with a way to respond to those. So those are the pieces that I think made this a particularly good coalition and one that I hope we can continue to use in other areas around fines and fees.
And if I could add just two little points about that. First of all, I think it was incredibly powerful in Idaho because, as my understanding, amicus briefs are very rare in the Idaho Supreme Court. And so when you get something like that, and especially when you get a big group and a coalition that has a signal that you don't, maybe something like the United States Supreme Court that gets a million of them, it wouldn't matter. Second of all, it mattered in this case a lot because, I'm not a 14th Amendment person. I don't pretend to know a lot about it. I'm busy. I just tried to get the damn thing in there and get it filed. I knew it was wrong, but it wasn't clean. Okay. But you can look through, you'll see all the typos in my original deal. That's just the way it is for public defenders on the ground. I hate to say it, not to make excuses, but I think what the amicus did, or what they was so powerful in this case as well, is that it made those finer 14th Amendment points that I did not make in my briefing. And I think that I don't know a lot about amicus briefing, but I can see where in the United States Supreme Court context, where you've got the best firms doing the original briefing, you could question how much value the amicus would come in. But in a case like these, or in a case like you guys might find in your area, that you're filing it when you're really busy, if you look at this amicus brief and you attach it as an exhibit to your petition, which I would do, I think it is an enormously powerful thing, because the writing here is just so much better than your day-to-day public defender is going to put in there. And that's not to speak ill, it's just time and experience and everything else. And so I think was just incredibly helpful in this case.
And let me just supplement really quickly, because I do want to say one of the critical things that made this successful is we got an awesome partner in our Cravath team that I really don't want to move on from this without giving them a shout out, because although we can provide them some guidance on the doctrine, that's not obviously what sort of Cravath specializes on. They did an excellent job with this brief. And obviously it was an iterative process between the amici and the firm, but you can really get some. So one thing is get a really good firm on hand if you want them to be a partner for drafting the amici brief.
Agreed.
That's absolutely true. And it was especially true in this case, because the timeline, as Pete said, it's fast. And it was very fast with respect to the amicus, because Idaho is, as Pete said, it's the Supreme Court. You don't file your application to file an amicus brief with your brief. You file that application first, and then they tell you when your brief is due. And they gave us 2 weeks, and that was it. And without Cravath, who were our pro bono counsel, I don't think we would have gotten this done. So absolutely right.
Pete,
Pete, well,
can I
go
just
ahead,
interrupt?
sure.
We got a question from the Q&A that's kind of related to the points Pete was just making. Having gone through this, how would you advise others to beef up their initial pleadings? What can they do at the trial level or at the writ level to make their cases stronger? You suggested adding amending the amicus brief to their stuff. Are there particular arguments that you wish in hindsight would have helped?
No, I don't think so. I think the arguments I raised were right as far as, and I think that at least in my case, there's an 8th Amendment argument too, because of the bail schedule that was set. I think the difference is not arguments that I wish I would have raised. It's clarity that I did not have. So I said, this violates the 14th Amendment, due process, equal protection, but it's not clean. When you read that amicus brief, it's like, I don't know, it's like John Krakauer wrote it or something. It's so crisp and clean and just in a way that I wish I could write, and I can't. And so it's not that I raised, that they, made point or, issues I didn't raise, or these broad issues. It was the cleanliness of it. And I know that, as by the opinion and, whatever, you can see that had an impact on it, and they just made it so much cleaner and more palatable. And so I would say that the general issues are the same, but just follow the way they did it, not the way I did it, as far as the cleanliness of their work.
Great.
So Pete, at oral argument, one of the justices asked you the following question, and I'm paraphrasing. Suppose at sentencing, a defendant is ordered to pay fines and fees, and she says something to the effect of, I'm never going to pay those fines and fees. Could the court issue a warrant when she fulfills her promise and doesn't pay her fines and fees?
Yeah, and so that question was posed to me by Justice Brody, and it was the best question that I received in the whole thing, in my view, from start to finish. And the reason is because it distinguishes between the 4th Amendment analysis and the 14th Amendment analysis, which is harder to get your mind around, at least for me, than I thought it would. And I struggled for a while. But basically, if the individual says that, I think that would give them in the future probable cause, and therefore that the failure to pay was willful. And therefore, I do not think it would violate the 4th Amendment if somebody said that. But I still think it violates the 14th Amendment, because Bearden stands, and Bearden, and these line of cases stand for the proposition that it violates both equal protection and due process clause of the 14th Amendment to incarcerate somebody for without first holding a hearing or providing due process. And also, because they're indigent, and if you're issuing the warrant, then it violates equal protection for incarcerating. Again, the term incarcerating is so important because it sort of alleviates this issue of, is it probation? Is it contempt? Is it failure to pay, or is it failure to show at this hearing that you never had notice of? The issue is incarceration without due process, or incarceration in violation of equal protection. And so I think that question so profoundly shows the difference between the 4th and the 14th Amendment analysis, and shows that in my view, the 14th Amendment is quite a bit higher burden for the state than the 4th Amendment. And so even if you had probable cause to justify the warrant, you still can't get over the 14th Amendment issue by just issuing the warrant without having the hearing first.
Great. Orion, are there alternatives to a writ? What about affirmative civil litigation to address these arrest warrants?
There are, and so there's a number of tools that advocates have used, and writs are not ones that we as civil litigators are kind of have the same level of expertise that Pete has. So there are a number of different routes that you can take to solve this problem. The issue is that all of them have problems. All of them have real complications, and one of the reasons why it's so useful to have public defenders like Pete as the front line of defense to raise these issues in the initial instance and be the sort of gatherers of the facts at the time, is that trying to address these cases on a broader affirmative impact litigation lawsuit brings with it a ton of different difficulties and complications. So for one thing, if you file in federal court, which is where many civil litigators file, any federal litigators will tell you there's a huge array of protections that the state judicial system enjoys in the federal court. So you have a ton of doctrines that you've got to jump over, like Rooker-Feldman, like Younger abstention, which try to get which I think are actually far narrower than they're often applied, but they can provide a federal court with an excuse to not do something because it's not its deal, it's not its issue. And what's sort of really good about the petition that Pete brought is that it brought it right, like this was a problem in that court, and it brought it right to the doorstep of the highest authorities. Like he said, it's sort of tattling to the highest authorities there, and that can be a better, I think, often than going to this other forum, this federal forum, where you don't actually know if they'll take that seriously. But the problem with the petition route, as we know, is that it really will only technically affect that case. And when there's a systemic problem, when we know that an entire county is funding itself by imposing warrants like the one in Beck's case, then you often need affirmative litigation. And that's when, if you see a systemic problem, it really helps if you can loop in the Fines and Fee Justice Center and other advocates, because we can start to provide the resources to tackle some of those issues on a broader basis. The other thing I'll say, and I think Pete has mentioned this before, that half of the battle here is often naming and shaming. As happened in this case, they tried to moot this case out because they knew, oh, we got busted by Pete. We totally got busted, and now the big Supreme Court knows, and we'll try to solve everything and settle it. And I'm very grateful for the arguments about mootness that Pete tackled successfully, and for the Supreme Court really recognizing that this was a systemic problem. But here's the thing. Even if that hadn't happened, let's say there's a different state where the Supreme Court doesn't have as much of an appetite for this issue. That's really really a problem, but you may be able to still stop some of the immediate abuses simply by bringing the same petition that Pete brought. And even if you don't get a precedential decision, which of course we want, and we want to be able to apply it, you can still stop that abuse in the initial instance. So some things that you can do in federal court is to seek a declaratory judgment. You can't sue judges directly for damages or even for an injunction under Section 1983. If they're acting in their judicial capacity, they're immune from that. But you can get a declaratory judgment. And if there's a particular judge who's a real bad actor, that may be a tool for litigators to name and shame that individual and try to get some measure of reform. Is that helpful? Does that answer your question?
Yeah, definitely.
And
Tim, are there other questions?
Yeah, related to the kind of litigation strategy is one of the comments was great that it worked in your state. In our state, what they see is people are being incarcerated for failure to appear warrants, not for the underlying non-payment. And so what are your recommendations for kind of addressing that?
It's a huge issue. Pete, do you have anything? I'm happy to provide some, but Pete,
I do, and I want to hear what you have to say too, because I've thought a lot about that, and I know that issue was raised in the Ferguson case, in that issue that happened in Ferguson. Yeah, and I believe that the failure to appear, if they don't have personal service, they can't hide behind it because it still violates the 14th Amendment. So the issue is if they send it out, then the notion that they can then, and I also believe that it violates the Fourth Amendment, because, fundamentally, at the end of the day, you have to have probable cause that you committed a crime. So if the crime is failing to appear, where is the probable cause that you got the notice? And without that, it still is unlawful under the Fourth Amendment, because there's no, you have to have notice before you can willfully not appear, and hence, it's still a Fourth Amendment violation, Second of all, as far as the 14th Amendment goes, you're back to the same issue again. So I think that the failure to appear issue is obviously trying to be sneaky about it, and on the other hand, I think that constitutionally it's no stronger of a case than the contempt case, because unless you know the person got it, and then therefore they didn't come, you don't have probable cause under the Fourth Amendment, and you don't have, it still violates the 14th Amendment. So I think that the writ would be just as effective under those facts as in a contempt case.
Yeah, so I'll say this has become a huge issue, because of course there are some jurisdictions that have been pulled in either by public defenders or other states and have stopped issuing failure to pay warrants. But then, just as Pete was saying, they sort of sneakily tried to sidestep it by setting up a different regime that ends up in the exact same result. It's a big problem. Pete and I have sort of talked about this a little bit, at least in the mooting context, and in the state of Idaho. I really like the set of answers that he put up, that he constructed around notice, the requirement of notice, the fact that the state is not going to pay for everybody to get notice, and that can be a really good defense against these failure to appear warrants. I'll say that my view of the 14th Amendment, the fundamental doctrine, is that this makes the case a lot harder, a lot more complicated for us to bring a systemic challenge on it. And the reason is that the Bearden line, the line of Bearden cases, really is about being punished solely for inability to pay, solely for failure to pay. And the states and the court system is going to start to say, well, if you didn't pay, but you just didn't do something, you didn't appear, that has nothing to do with your financial circumstances. That just has to do with you not showing up and you not fulfilling other terms of probation that have nothing to do with money. So it is really hard. It's a different type of hard case to challenge. And as sort of Pete was mentioning, we've tried to go for like the more low-hanging fruit, the more like red-handed abuses where they're directly violating the letter of Bearden, rather than some of these things that are just one step removed. But I'm totally sympathetic to the fact that, as you see on the ground, that the result of that regime, a failure to appear regime, can be almost identical, where exactly the same set of abuses and injuries are happening to the community because of failure to appear warrants. What I'll say, and I haven't done this, so I welcome thoughts from other folks in the advocacy community on this. I do think there's a lot of due process potential challenges to this. About there's some regimes that are put in place where they know they're technically issuing some sort of appearance notice, but they don't want the person to get it. They don't really want, they want to make it scheduled so you have to come in at like 9 to 9:15 on a Tuesday when they know everybody's working. So I think there may be some opportunities for certain types of due process challenges to the system of failure to appear warrants that exist in a given state. But the bottom line is a lot of this is going to be policy, and you just have to start working with the court systems, the senior administrators, the Supreme Courts in that jurisdiction to say, this is a bad system. It's not going to help you get money. It's just going to harass people. Set up a system where people can reschedule if they need to appear. Set up a system where people can ask for modification of the underlying fees. I think Lisa probably knows far better than me that if you have a regime like that, people will appear, people will pay what they can pay. That is a better scheme than the ones that they have in place. But I know that might not be satisfying. That's my unsatisfying answer to that. Very good.
And let me say, I agree completely. The failure to appear problem looms over this field in all kinds of contexts, from driver's license suspension to warrants. There is a lot of work being done about ways that people who need to appear in order to resolve a problem with a court can do it in different ways. One of the things we've learned during the pandemic is that failure to appear rates look like, and I say look like because this is not yet confirmed by hard data, but anecdotally from a lot of courts around the country, is that failure to appear rates are actually dropping when people are able to appear virtually. And that's not surprising to anybody who's worked in criminal courts. People don't want to go to court. They're afraid they're going to get arrested when they go there, or they do have poverty related issues. They can't afford childcare. They have, somebody's got to watch kids. It's the middle of the workday, whatever the reasons are that people can't get to court. Some of those can be solved by technology and appear to be doing better. Lots of courts are doing things like text messaging people the same way you get a text message from your dentist when you're due to get your teeth cleaned. That doesn't solve the legal problem. And I think the one thing I would say on the legal doctrine is making sure that if you can, that you raise the notice issue if you're taking a case like this on petition, because it is important that it be personally served. Otherwise, it's just an end run around the warrant provision. Because if a person doesn't, if your solution to warrants without probable cause is an order to show cause and a hearing that is then sent by mail to somebody and they don't get personal service, to me, that's just one step removed from what you just said was unconstitutional and not a very big step. And so I think that insisting on that personal service, and at least trying to get a court to say that that's a necessary component of this, is important.
One other question that came up in the chat, I think is kind of related to some strategy around some of these arguments, is is there a concern that ability to pay hearings may have an unintended consequence, making wealth extraction more efficient? And is that something to be concerned about?
Well, let me.
This broke up. Can you repeat that? I'm so sorry. My line broke up.
The question was, could ability to pay hearings that this would result in have the unintended consequence of making wealth extraction more efficient?
Got it.
Yeah, so let me just say generally, because I'm going to give a shameless plug for Fines and Fees Justice Center. There's no question that how an ability to pay determination is made in this context is really important. We have guidance, that's my shameless plug, for how courts should do it. If they followed our guidance, I think we would not have more wealth extraction. And I say all the time, too much judicial discretion is not a good thing. And in the context of ability to pay assessments, it's definitely not a good thing. And so you want to be sure that at the same time that you're working on a case like this, you've got advocates working with your judges to try to enact some policy around how they make these determinations, because left to their own devices, we all know often what happens. I don't think that ending arrest warrants is going to result in more. I think it results in less, because the harms to people and their families and communities are less when you, I mean, if you take jail out of the picture, as Orion said, it's just in and of itself such an enormous disruption. But it's also not possible for people to pay what they don't have. And if a judge does an ability to pay assessment at all, the worst that happens is you end up in the same place you were beforehand, a little bit like Ms. Beck in the first instance. That is, the judge says, no, I'm not going to reduce the fines and fees. That's not any worse than what we currently have.
I would add that, oh, sorry, Orion.
Please.
I would add that and this is where Orion and I probably disagree a little bit, but my contention, as I stated earlier, is that this we're in this boat primarily because it's easy. At least that's my experience, and that it's the path of least resistance. So whether it's issuing warrants or whatever else, to me, the ability to pay hearings are so important. And if I look back and say, okay, what are my biggest regrets as a public defender? This is maybe one of them. And I'm throwing sort of stones in a glass house, if you will, is not fighting this issue hard enough on the ability to pay hearings at the time of sentencing and making a big deal out of it and spending an hour in court and asking for 13 family members to come up there and talk about what a huge impact this is having on their lives, because it is. And I think that it's the difficulty of it that will get this issue solved, and that the primary reason that they do it and they just issue the fines and issue the warrants and whatever is because it's difficult. I think that courts know that the issue of writing lots of tickets is a great way for revenue, but issuing warrants and whatever for the people that aren't paying, the people that can never pay, is a waste of resources. It's just easy. And I think that making the fines, making it painful to impose the fines, which it should be. The court should know, not just on the defendant, but on the defendant's children, on the defendant's family. All of these people have a right to come in and speak their mind and say how hard this is for them. And I am throwing stones in a glass house here, but if you did that and it made it where it was difficult, I think you'd see courts back way off of what's going on, only because it would take their entire day to have these ability to pay hearings. And that's the end of the day what they don't want.
Yeah, I was going to say almost exactly the same thing. So it's not a point of disagreement. I do think often jurisdictions set up their fine and fee system in a way because at aggregate, they're making some type of money from, middle-class people, I suppose, who are paying without paying attention to the large number of people who can't pay. But the broader issue is the way the American constitutional system works, and maybe it shouldn't, maybe there are better ones, you could look at other models, is that the procedural requirements of the Constitution create obstacles that become substantive, that make it harder for the state to punish. So, basically the Constitution imposes a limit when the state wants to act as a debt collector. And as soon as you've got that limit, just as Pete said, the state is going to back off because it's just going to be harder to do this. It's going to be harder to deal with it. And then that's when advocates can move in, not just with litigation, which is very much a small piece of the puzzle here, but to try to reform the whole system and say, this is the way that you should set up a just fine and fee system. This is how other Western countries do it. This produces, we've had a lot of research into day fines that, fines that have a maximum cap, but essentially, are pegged to the amount of income that a person has. So everybody is experiencing the same sort of amount of pain from the fine. That's where you can move once you've got that. Once you assert this legal obstacle, it gives you a way to try to reform the whole kind of economics of the system.
Tim, do we have other questions?
Yeah, so one of the questions real quickly for Pete was, did the Idaho Supreme Court opinion require written findings on the record of ability to pay?
I don't believe so. I can't, I'd have to look back, but I don't believe so. I believe that, the decision didn't address, a requirement that an ability to pay hearing be done. And so, maybe that would have been a good thing, but it's specific to warrants, right? It's specific to the issue of it, arrest warrants. So,
But an ability to pay hearing has to be done in that context.
in that
You
context,
can't
yeah,
issue a warrant.
I'm sorry. Yes,
without-
the ability to
right.
pay hearing has to be done. Yeah. Yes. Correct.
So there's
I thought you were
more.
talking about sentencing.
And presumably there has to be a record, right? I mean, there has to at least be oral findings. Somebody's got to say, you've got to make a willfulness finding. Is I think the only way that you can read that opinion.
Well, right, and I think that you really aren't, unless the defender raises it at sentencing, you're not going to have it. Period, because they're just not going to go out and personally serve these people. It takes so much time, and as I said, I mean, you take the summons and throw it out the window as you're driving down the highway, and you probably have as good a chance of them getting it as if you sent it to their last address. Sadly, because they don't live there anymore, and that's the reality, and that's a whole nother issue, but it's a sad reality. But the idea that you're just going to send it to that address, it's a waste of time. And so if the court actually has to go hunt them down, it's not going to happen.
So I have a question actually for both of you on this that's related to that, because there is a part of the opinion that was raised a bit of a red flag, a little bit of a red flag to me. And I just want to ask, because I may have misunderstood this issue, and I'm not going to, not everybody has the opinion in front of them, but there's a section where it says, in order to comply with Bearden, at minimum, a magistrate court's determination that an individual has the ability to pay must be based upon sufficient facts alleged in the deputy clerk's affidavit, or when available, facts testified to at a sentencing hearing, which is sort of what we're discussing, right? And to me, that's a bit of a red flag, because if your conviction or sentence was, 10 years ago, and there are facts that were testified to at that hearing, circumstances could have changed, or there could be a difference now. And so to some extent, it is good that they're saying that they require this ability to pay hearing with regard to the warrant. But if sort of outdated or stale facts from the hearing could come in, then that seems like a bit of a red flag. We need to make it clear, I think, to courts that the ability to pay hearing really has to be very, soon in time to the action that's being taken to for the warrant. So I don't know if Pete and Lisa, you have thoughts on that. I may have misinterpreted this part of it, but it is something that was a concern.
I think you're right as a matter of law, but I think that your concern is there's nothing there.
Not going to happen.
And the reason I say that is because they're not going to go back and look at it. They're not going to go. That's work. They're not going to go back and look at it. If whatever was said, they're not going to, they'd have to go back and get the record and look at it. This is an automatic generating, get it out the door. If you had to actually go back now, as a matter of law, I think you're 100% right. And I think it would be problematic. But I think as a matter of course, at least in my experience, this is all about how fast I can get it done. And as long as they don't pay and I can issue the warrant, we're done, boom. If I had to actually go back to the clerk and ask for the record and go listen to it and decide if the person had an ability to pay and what they said at the hearing and all that other stuff, I don't think they would do it.
I think that totally makes sense and is good perspective. I think that as other advocates want to look at and use this opinion, they do want to be cautious about that to make it clear if this is used in courts in the future. Again, it's a really good decision, so I'm not trying to nitpick it, but to be clear that you need it, not exactly contemporaneous, but you need a roughly contemporaneous ability.
No, I actually think it's a really good point, and that I agree. I think the standard you want to at least argue for is that they have a present ability to pay. And that doesn't mean, even if sentencing, as in Ms. Beck's case, it wasn't that long ago. She was working, sort of. I mean, not very many hours, but she was working at the time. And if someone had gone back and looked at that record, they might have said, well, the lawyer made an argument to waive or reduce, and the judge must have implicitly found she had the ability to pay $25 a month. And therefore she's got the ability to pay. And I think you want to argue that it's present ability because circumstances change. And again, particularly currently, but at any point, people lose their jobs. Someone who had the ability to pay $25 a month 2 months ago may not have it today. And so I think keep trying at least to argue for a standard that is the current ability to pay is important.
And I would add one other thing to that, and that's in the Fourth Amendment context, which is that you have a staleness issue too. When back to the probable cause issue, they can't go in and say, 2 months ago I was over to Ryan's house and I saw some stuff there. I mean, there's a staleness issue. So again, we go back to this willfulness part. Where is the probable cause that this person today doesn't have the money? And that's a lot higher deal. And I think that if you really focus in on the language of the Fourth Amendment, and each one of the states obviously have their own, basically identical language too, there has to be a crime. And I think that's also an avenue, as we noted earlier, to get after this failure to appear thing. What crime do you have, and what a probable cause on each element of that crime?
So I think we're running close to the end of our session. Let me just say a couple of things. One is, one thing we didn't address, but I think it's important to think about, is litigation and legislation can often go hand in hand. And there is an underlying dynamic sometimes. And part of the reason for bringing a case sometimes can be to help raise the profile of an issue and to help make it a policy problem that a legislature has to solve. And so I think it's important to always be thinking about the legislative context when you're doing litigation, and for folks who are doing policy work to be thinking about how the litigation that might be happening in your state can help fuel some of the legislative work that you're doing. And one example of that is in Nevada, where, as is the case in 13 states, traffic violations are still misdemeanors. And we were able to successfully pass legislation that decriminalized them. And that means that the state the courts can no longer use warrants under Nevada law for failure to pay. And it was a legislative fight around these issues. There are sometimes legislative solutions. The law goes into effect in January of 23, but there are still 12 other states where that's the case. And from a legislative standpoint, that's a way to address some of these problems, because without explicit authority, the Nevada courts can't, and there is none, the Nevada courts cannot now issue arrest warrants when people miss a payment under a payment plan. And there were quite literally hundreds of thousands of outstanding traffic warrants for failure to pay before the legislation was enacted. So I encourage people to think about that. I know there's still some questions. Please don't hesitate to reach out to us if you have questions about this decision or any other case. I reiterate my invitation: if you have a case and you want help, whether that's amicus help or that's help finding pro bono counsel, or someone else who might be able to pick up a case, please reach out. That's what we're here for. So
and we will do our best to answer those questions that went unanswered individually, and do some follow-up with each of you.
Indeed. Thank you all. And thank you especially to Pete and to Orion for being with us today.
Thank you for the opportunity. It's such a big issue.
Thank you for working on this so as incredibly as you have for so long. Really appreciate and the time to talk to all of you.
Bye.